Well, good evening and welcome to this special edition of Reality Check. Over the next half hour, we're going to take a look at some of the recent bills that have negated many of your constitutional rights. That includes the ways the feds have claimed that in order to fight the war on terror, they must remove your constitutional protections. So here's what we've got on tap for you tonight. A bill known as the NDAA, or the Enemy Expatriation Act. It essentially allows the feds to strip you of your citizenship if you're declared a terrorist. I'll give you an update on what's happening with the NDAA. We're also looking at the president's power to assassinate U.S. citizens who have been declared terrorists, even when those people have never had a trial. There is at least one case so far. And we're also going to explain one of the most stunning bills ever passed by the U.S. Congress and signed into law by any president. A provision in the National Defense Authorization Act allowing American citizens to be arrested and held indefinitely without charges or trial, simply because the president deems them a terrorist. And we're going to show you why, despite President Obama's public stance of being uncomfortable with this power, why it was his administration that demanded the power. Let's begin with the NDAA and what it's all about. The National Defense Authorization Act is, in and of itself, really nothing shocking. In fact, it's a bill that is regularly passed by Congress to fund the U.S. military. But it was in 2011 that a provision within that bill made it anything but ordinary. The provision to allow any person who's deemed an al-Qaeda operative or an operative of one of the affiliates to be held indefinitely without trial. In December, just after the Senate passed the bill and sent it on to the President, we gave you the details of this bill. The National Defense Authorization Act does more than just fund our military. Tuesday, the Senate approved moving forward on a vote. But it was in June when I first told you the House approved this bill, and as I told you then, it includes Section 1034. That section states, the United States is engaged in an armed conflict with al-Qaeda, the Taliban, and associated forces. Notice that term. And those entities continue to pose a threat to the United States and its citizens, both domestically and abroad. It goes on to give the President the authority to use all necessary and appropriate force during the current armed conflict with al-Qaeda, the Taliban, and those associated forces. So let's look at this one piece at a time. Who does the President have the authority to take action against? This isn't just al-Qaeda. Again, it's any one part of an associated force. Associated forces that are engaged in hostilities against the United States or its coalition partners. Any person who has committed a belligerent act, or any person who has directly supported such hostilities in aid of such enemy forces. And in those cases, what can the President do? Well, among other things, the President can place these people into detention under the law of war without trial until the end of hostilities. The only problem with that is that the end of hostilities doesn't really mean anything when fighting a war on terror. See, there's no actual declaration of war, nor is there a provision that lets us know when the war on terror will be over with. Under the authority of this bill, even a U.S. citizen simply suspected of terrorism would not have to be judged by a court, but could be arrested, held without charges, even sent to detention overseas without due process. Kentucky Senator Rand Paul argued with one of the bill's authors, Senator John McCain, on the Senate floor Tuesday.
Under the provisions, would it be possible that an American citizen then could be declared an enemy combatant and sent to Guantanamo Bay and detained indefinitely?
I think that as long as that individual, no matter who they are, if they pose a threat to the security of the United States of America, should not be allowed to continue that threat. And I think that's the majority of American public opinion.
Senator Paul isn't alone in his opposition. In the Senate, 37 U.S. senators voted to remove this power from the defense bill, but they were defeated by the votes of 61 senators.
27% of detainees who were released got back in the fight and were responsible for the deaths of Americans. We need to take every step necessary to prevent that from happening.
If 27% of detainees, by the way, got back into the fight, that means 73% did not. But here's what you need to know. Have you heard people say that if you're not doing anything wrong, you have nothing to worry about? Lawmakers and law enforcement say that all the time. But who didn't say that? The framers of the Constitution. They didn't create rights like the right to a speedy trial, the right to have your charges against you made known, the right to challenge your accuser in court, the right to a trial before a jury of your peers, because they were trying to find loopholes for the guilty. Those rights are there for the sake of the innocent, so that through due process, your innocence can be proven. And that is reality check. And of course, at the time that the Senate sent that bill on to the President Obama was saying that he would in fact veto that bill because of Section 1034. It turns out that not only would the President sign that bill into law, but his administration, well, they may have been the ones who demanded the provision be included in the first place. That part of the story when we come back. Well, welcome back to this Reality Check half-hour special. Before we go any further, I want to comment. Matt Whitlock on Facebook says, "This is America, Ben. The accused don't have to prove their innocence here. The accusers have to prove their guilt." Before the break, I mentioned in that past Reality Checks that sometimes you have to prove your innocence. And in the war on terror, that certainly is the case. Sometimes those protections in the Constitution are there so that you can prove beyond a shadow of a doubt that you are innocent when you say that you are. But before the break, we also took a look at the 2011-2012 National Defense Authorization Act. As we showed you, because of Section 1034, that bill did much more than just fund the military. It also negated many American rights protected by the Constitution. President Obama had warned Congress that if they sent him that bill, though, he would veto it. But he didn't. And it was over the New Year's holiday that President Obama signed the NDAA into law. I told you about the powers in the National Defense Authorization Act, the NDAA, weeks ago when the bill first passed the Senate. A reminder, now this bill allows for funding for the military construction, and for defense activities of the Department of Energy. But there's also a provision that gives the President of the United States the power to detain terror suspects, even if they're U.S. citizens, and hold them indefinitely without trial. Today, the White House issued a statement to put fears of what that means to rest. I want to clarify that my administration will not authorize the indefinite military detention without trial of American citizens. Indeed, I believe that doing so would break with our most important traditions and values as a nation. My administration will interpret Section 1021 in a manner that ensures that any detention it authorizes complies with the Constitution, the laws of war, and all other applicable law. The President, while on vacation, signed the bill into law, even though he has made clear that he objects to sections in the NDAA that regulate the detention, interrogation, and prosecution of suspected terrorists. So now that this bill has become law, just what power does the President now have? Well, under the provisions of Section 1021, the President is afforded the absolute power to arrest and detain citizens of the United States without their being informed of any criminal charges, without a trial on the merits of those charges, and without any due process safeguards protected by the Constitution of the United States. But even as President Obama puts on the face of seeming reluctant but willing to accept these new powers, don't believe everything you hear. I want to remind you that according to Democrat Senator Carl Levin, it was the Obama administration who demanded the power of indefinite detention be placed inside the bill.
And I'm wondering whether the Senator is familiar with the fact that the language which precluded the application of Section 1031 to American citizens was in the bill that we originally approved in the Armed Services Committee, and the administration asked us to remove the language which says that U.S. citizens and lawful residents would not be subject to this section. Is the Senator familiar with the fact that it was the administration that asked us to remove the very language which we had in the bill which passed the committee, and that we removed it at the request of the administration, that would have said that this determination would not apply to U.S. citizens and lawful residents?
So here's what you need to know. How do the American people who know of this bill feel about it? Well, go to opencongress.org and see for yourself. Of those voting, only 2% support the bill. This is not a partisan issue. This is a freedom issue. If President Obama truly believed that this was too much power for the office of the president, not only would he have not asked for it in the first place, he would have vetoed the bill. Why? Because if he really believed this power for indefinite detention was unconstitutional, to the point that he has promised to never use it against American citizens, he would have vetoed the bill to prevent the next president, and the one after that, and after that, from using that power against the citizens of this nation. And that is Reality Check. And so the tough question even tonight, should you trust this president or any president for that matter with your right to a fair and speedy trial, your right to know the charges against you, your right to face an accuser in court? The reality is there are bigger issues here than just indefinite detention. How about the fact that our government is already ordering the deaths of U.S. citizens and their children without trial? How that's happened when we come back. And welcome back. We've been talking tonight about how the war on terror has negated so many of our constitutional rights, including the right to life, liberty, and the pursuit of happiness. But perhaps the most critical of those rights, the right to life, has also vanished depending on whether a U.S. citizen is deemed a terrorist. If you are, apparently there's no need for charges or a trial. That is what U.S. citizen Anwar AlAwlaki's family discovered late last year. Well, it was back in April. In fact, it was one of the very first reality checks I did here at Fox 19. I talked about the attempted execution of cleric Anwar AlAwlaki, who was in Yemen. At the time, I told you that AlAwlaki was a U.S. citizen, born in Las Cruces, New Mexico. He lived in the U.S. until he was 7 years old. His family then returned to their home country of Yemen.
The death of AlAwlaki is a major blow to al-Qaeda's most active operational affiliate.
Well, that is true. AlAwlaki was the head of al-Qaeda in Yemen, and after the death of Osama bin Laden, AlAwlaki was the most influential leader in al-Qaeda. U.S. intelligence say that he was the one who influenced the Fort Hood shooter, Major Nidal Hassan. They also say he influenced the wannabe Christmas Day underwear bomber and the foiled Times Square bomber last year, also reportedly influenced by AlAwlaki.
They've been tracking him for months. In fact, in May, the president put out an executive order saying he could be killed or captured. It's the first time we've done that with a U.S. citizen.
And that is also true. AlAwlaki was, until his death Friday, a United States citizen. And killed with him during that bombing, a second U.S. citizen who published a jihad newsletter. It is true that both men could be regarded as enemies of the United States. But does the government deciding you are an enemy of the state mean that your rights under the Constitution are suspended? Neither of these men were killed on a battlefield. As U.S. citizens, they were not charged with any crimes. They were not indicted by a grand jury. They were not given a military tribunal. Instead, the president ordered their deaths without any due process. And that due process is not just some good idea. It's the very structure of our Constitution. This targeted assassination program started under President Bush and has greatly expanded under the Obama administration.
There's so much that's unconstitutional. Somebody said, would you be able to vote to impeach that? I said, I probably would have been able to impeach all the presidents.
But that is not going to happen. Republican presidential candidate Ron Paul, one of the lone voices challenging this action, alluding to the fact that the president ordering the death of any American citizen violates the Constitution and could be an impeachable offense. Paul, by the way, though, acknowledged that there would not be any kind of support for that action in the U.S. Senate. So here's what you need to know. The Fort Hood shooter, Major Nidal Hassan, is a U.S. citizen. He actually shot and killed people in cold blood at Fort Hood, but was not executed. He gets a trial. The man who influenced him, also a U.S. citizen, is killed without due process, simply by order of the president. And because the information against him is classified, no one, not even U.S. courts, can even see the evidence of why he had to be killed. You see, this issue isn't about Anwar AlAwlaki. It's not about President Bush. It's not even about President Obama. It's about a nation's constitution that keeps that kind of power out of the hands of one man for a reason. And that is Reality Check. And a quick note there, 2 weeks after AlAwlaki's death, his 16-year-old son was also killed by drone strike. That son was at a barbecue with family members. And so that power to assassinate citizens without trial, it remains a very serious issue. In fact, one Republican lawmaker found a way that he thinks resolves the issue. Just strip those terror suspects of their citizenship in the first place. It's called the EEA, and I'll tell you about that after this break. Welcome back. Before the break, we told you about how President Obama ordered the death of cleric Anwar AlAwlaki without charges, even though AlAwlaki was a U.S. citizen. There was no indictment or even a trial. Now, that move clearly flies in the face of our Constitution, which is why 2 congressmen from either sides of the aisle introduced a bill that they believe fixes the problem. Or does it? The bill is H.R. 3166, also known as the Enemy Expatriation Act. It's sponsored by Republican Congressman Charles Dent of Pennsylvania and Congressman Jason Altmaier, a Democrat, also from Pennsylvania. A companion bill, by the way, was introduced in the U.S. Senate by Senator Joe Lieberman of Connecticut and Senator Scott Brown of Massachusetts. So what exactly does the EEA do? Well, it adds engaging in or supporting hostilities against the United States to the list of acts for which United States nationals would lose their nationality. Congressman Dent has a video in which he explains why this bill is necessary.
That a person who is purposefully and materially supporting acts of terror against the United States is demonstrating that they have no intent in acting as a U.S. citizen.
And that is pretty much the sum of why the congressman believes this act is important. But there is a specific case he also mentions as the catalyst for the EEA.
With the recent death of U.S.-born radical cleric Anwar AlAwlaki, the sanctity of American citizenship and its crucial role in our dialogue regarding national security is now garnering increased and bipartisan attention.
So this bill has been crafted to deal with issues already created by the execution of a U.S. citizen without any due process. Reality Check has been one of the only media sources calling out our government for its decision to execute Anwar AlAwlaki, a Muslim cleric in Yemen. As I've told you, U.S. intelligence agents claimed that AlAwlaki had influenced the Fort Hood shooter, the would-be Christmas Day underwear bomber, and the failed Times Square bomber. The president ordered his death, and it was carried out on September 30th of last year. A drone strike killed AlAwlaki, who was a U.S. citizen. He was born in Las Cruces, New Mexico. 2 weeks later, a second drone strike was used to kill his 16-year-old son, Abdul Rahman AlAwlaki. That 16-year-old was at a family barbecue at the time. He, too, was a U.S. citizen born in Denver, Colorado. But if the two were terrorists, why can't the U.S. go after them as the president did? Well, a couple of reasons, the most important of which is a little thing called due process. Under our Constitution's 14th Amendment, no state shall deprive any person of life, liberty, or property without due process of law. As I've told you in the past, AlAwlaki was given no due process, never charged with a crime, never indicted, never had charges brought against him in a military tribunal. He was not given the opportunity to face an accuser. And because of national security issues, the evidence against AlAwlaki was all a secret. You see how this works? So the answer, obviously, the Enemy Expatriation Act. If the Constitution protects citizens from having their lives taken without due process, then, as Congressman Dent said, just take away their citizenship, therefore taking away their constitutional protections.
Notably, this legislation would only modify an existing statute or law which has already been found constitutional.
So here's what you need to know. It is true that there is already existing law that allows for forcible expatriation. But what Congressman Dent may not realize, or maybe he does, is that even under the addition of the EEA, it would not have been enough to expatriate AlAwlaki or his son. First, the person must be over 18, so Abdul Rahman wouldn't have been eligible for expatriation. In addition, there is a high standard for revoking citizenship, and it includes this. The party claiming, in this case the feds, that a person has lost his U.S. citizenship has the burden to prove by a preponderance of the evidence the performance of an act of expatriation and the intention to relinquish citizenship. In Anwar AlAwlaki's case, there was no preponderance of evidence. Just two Justice Department lawyers making the decision. No judicial panel, no transparency, nothing. In fact, reports indicate that when the decision to execute AlAwlaki was made, it was 2 years before his death. And those two Justice Department lawyers, they never evaluated the evidence against him. Congressman Dent's EEA would not have legally applied, making it either ineffective legislation or just the first piece of reestablishing the law of forcible expatriation. And that is Reality Check. And I did mention the 14th Amendment there. Obviously that applies to states, but the 5th Amendment is the federal clause guaranteeing due process. Before we go tonight, I want to leave you with this. Many times people will say that the war on terror, it's changed everything. That there are new powers that must be utilized by the feds in order to keep the American people safe. And if we have to give up a few of those rights to be protected from terrorists, then it's okay. At least one of our founders would likely not agree. February 17, 1775, Benjamin Franklin wrote in his notes to the Pennsylvania Assembly these words: They who give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. Thanks for tuning in tonight. On air and to the thousands watching this live stream here in the U.S. and overseas, good night. The final quarter is next.